In today's video, we will talk about the U.S. court system, including the state and federal courts. We will discuss trial courts, appellate courts, and the U.S. Supreme Court. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. Understanding the U.S. court system is important to people studying law or criminal justice, or working in the legal or law enforcement fields, because having a grasp of those concepts can help you avoid confusion about which court is the appropriate place for a particular case and why. The topics we cover in this video can help you avoid making embarrassing mistakes on the job. So let's jump right into the U.S. court system with an overview of U.S. courts. We have a dual court system consisting of state courts and federal courts. Geographically, their jurisdictions overlap, but each one has its own type of cases that it can handle. Also, there are trial courts where cases start, and appellate courts where people can ask for review of the case if they are not happy with the decision of the trial court. In addition, we have courts of last resort, which are usually called Supreme Courts in the states, but some of them call them other things. And we have the U.S. Supreme Court. As part of the dual court system, in the state courts, we have separate courts in each of the 50 states and in the District of Columbia, also called D.C. A court can have jurisdiction because of geography. In other words, if a crime happened in a particular county, the state court in that county would most likely have jurisdiction over the case because of geography. There's also subject matter jurisdiction. That means that they would have jurisdiction over what the case is about. In other words, the crime that was committed. Then there's personal jurisdiction. If a court wants to hear a lawsuit, they need to have jurisdiction, personal jurisdiction, over all of the parties. Those can be people, companies, government entities, or other entities. And then there's venue. Let's say that two people are getting divorced. One person lives in County A, one spouse does, and the other spouse lives in County B. A case like that usually can get, the case can get filed in the state court of either county. The issue will be to decide which is the most appropriate location for the lawsuit to get filed. That's called venue. So that's a quick overview of state courts and geography. Now, the same jurisdictional issues that apply to state courts, as we just discussed, also apply to federal courts. That's the other part of the dual court system. The trial courts in the federal court system are called district courts. There are 94 total district courts, 89 of them linked to the 50 states. There are bankruptcy judges, and a lot of cases that end up in federal court might have been filed in state court except for what is called diversity of citizenship. Diversity of citizenship means that all of the parties to the lawsuit live in different states, whether they're individuals or companies or some other type of entity or organization. So that's diversity of citizenship. For example, if one person lives in Pennsylvania and they want to sue some other person who lives in Pennsylvania, they probably will need to take that to state court in Pennsylvania. But if the plaintiff in Pennsylvania instead wanted to sue someone in Florida, and there were no parties on both sides, meaning no plaintiff and defendant from the same state, the appropriate place to file that would most likely be in federal district court. Federal courts also have what is called federal question jurisdiction. These are things like lawsuits between states. If Missouri is suing California, that would be done in federal court, mainly because it would just look unfair for one state to decide a lawsuit that that state has against a different state. Lawsuits involving federal crimes are usually filed in federal court. Also in federal court, you will find bankruptcy cases, patent, copyright, and trademark cases, securities and banking regulation cases, antitrust cases, admiralty cases, ambassadors and other high-ranking public officials, and other cases that are specified to be handled in federal courts by federal statute. Some of the common issues federal courts deal with include constitutionalization of criminal procedure, discrimination laws and civil rights cases, discrimination cases, civil rights cases, and prisoner petitions. In addition to the courts that we've already discussed, there are some lower courts, like small claims court. In those, the maximum amount that can be in controversy can range from, depending on the state, from $2,500 up to $25,000. If people are suing about a dispute that involves more money than whatever is appropriate for the local small claims court, they will have to go to what a lot of people call the regular court, which is the trial court for that jurisdiction, usually the county court. Small claims cases often involve things like debt collection, non-payment of goods and services, and landlord-tenant disputes. In addition to small claims courts, other lower courts are called Justice of the Peace courts. Justice of the Peace courts, and there are municipal courts as well. These lower courts, small claims courts, Justice of the Peace courts, and municipal courts, often have inadequate financing, inadequate facilities, and really unbalanced workloads. One division of the court might have 500 cases set for trial in a month, and another division might have 25. Also, there are attempts at community justice. This is where people engage in alternative dispute resolution like arbitration and mediation to try to resolve conflict more peaceably than a knockdown, drag-out trial in court. It can also be a lot quicker, but not always, and much less expensive, but again, not always. Arbitration is where two sides to a dispute will go in front of an agreed-upon party who will hear the case in a much more informal setting, like in a conference room, and make a decision. Sort of like a judge, but in a more informal setting. And the parties will have signed an arbitration agreement at the beginning or ahead of time as to whether they will accept the arbitrator's decision as binding. Even if it is binding, they can almost always go to regular trial court if they are unhappy with the result. Mediation, on the other hand, is where the parties to a dispute will meet with a neutral person who will try to help them resolve the case. There are multiple styles of mediation. In some, the mediator acts more like an arbitrator and just tells the parties what their decision is. In others, like transformative mediation, they try to teach the parties to see the dispute from the other side and to learn how to resolve their disputes peaceably in future situations and gently guide the two parties to finding their own common ground and resolving the case themselves. Also, there are community courts, like the Midtown Community Court of New York City. These are outside of the standard state, county trial courts and appellate courts and that hierarchy. But again, usually people can appeal from community courts to a standard trial court. There are problem-solving courts, and if your head's spinning now, yes, that's understandable. Don't worry, that everyone has that experience because as you've gone through your life to this point, you had no idea that there were so many different kinds of courts. There's therapeutic jurisprudence, which is non-adversarial adjudication, and people intervene immediately, but it's hands-on judicial involvement that sends people to treatment programs with clear and defined goals, and lawyers for either side don't get involved much at all with that. There are drug courts, domestic violence courts, and mental health courts. These are all focused on specific problems. Of course, part of the problem with that is people will game the system once they learn, and they do learn quickly, what the system wants to hear them say. Also, what if someone needs drug court and mental health court, or domestic violence court and drug court or mental health court? Which one do they get sent to? Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses information like the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. The higher these videos are in the results, the more people I can help. Thank you. All right, let's talk a little more in depth about trial courts. And for this purpose, we're talking about state trial courts. Just as it sounds, trials are held in the trial courts. In addition, and as part of the trial being held, the trial courts are where jurors get selected and sworn in, and witnesses get questioned. At the lower level of trial courts, in some places where they do have multiple levels, the lower levels will process felony cases, but only to a certain point, and then the cases get sent to the major trial court, which is responsible for the final phases of felony prosecutions. So the second level is called the major trial courts. There are over 3,000 major trial courts in the 50 states. Jurisdiction is defined geographically, and it's usually on existing political boundaries, like counties. There are over 10,000 judges in the major trial courts, and they handle over 30 million cases a year. They handle criminal cases and civil cases. State courts typically hear what are called street crime cases. The federal courts tend to handle more of the what is called white-collar crime. Most criminal cases don't go to trial. They get plea bargained or dismissed or otherwise resolved. Civil cases, however, dominate the dockets of most trial courts. You would think from watching television that all the courts here are criminal cases, but the vast majority are civil cases like domestic relations, divorce, custody battles, handling estates where there might be wills filed and contested, or just a will getting administered, and personal injury cases. Those are some of the more common civil cases. There are different names for trial courts in different states. Yes, this does definitely add to the confusion. But let's take a quick spin through the different names for trial courts in different states. The trial court can be called a circuit court in some places, a court of common pleas in others. Some call the trial courts chancery courts, district courts, superior courts, and in the state of New York, the trial court is called the Supreme Court. I know that sounds backwards, and it does seem that way, and it causes a lot of confusion. Also, there are appellate courts. Now, the trial court will be the court of original jurisdiction. They do the fact-finding, and they apply the law, and they decide guilt or innocence, and they determine sentences. Appellate courts merely look at what happened at the trial court level, decide if the judge made any errors during the trial, like admitting evidence that should not have been allowed, and they determine if the judge applied the correct law and interpreted the law correctly. At the appellate court level, there are no trials, no jurors, and no witnesses. The lawyers for each side go in front of a panel of judges because there's more than one judge hearing the oral arguments at the appellate level. And they listen to oral arguments, and usually at some later date, which could be weeks or even months down the road, they issue their decision. Some states have more than one level of appellate court. State high courts of last resort. In most states, these are called the state Supreme Court. Texas and Oklahoma both have two courts of last resort, with one being for civil cases and the other for criminal. All other states have one state high court of last resort. The dockets are purely discretionary, meaning the state Supreme Courts can almost always pick and choose which cases they want to hear. On the state Supreme Courts, there is a panel of judges, similar to in the Court of Appeals. And then we get to the U.S. Supreme Court. Let's talk about the U.S. Supreme Court. It is the court of last resort for the entire United States. The cases the Supreme Court hears are hand-selected by the justices. They hear fewer than 85 cases a year, and they usually will only hear cases that impact society as a whole. Often the cases deal with constitutional questions. The Supreme Court justices, there's 1 Chief Justice and 8 associate judges. They're all appointed by the U.S. President, and the U.S. Supreme Court was created by Article 3 of the U.S. Constitution. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing will not cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called Who Does What in the U.S. Criminal Justice System.